What concerns me is the fact that these cases submitted for wholesale amnesty have been pending with the PARD, or Protest Appeal Review Department, for 9 years. Such failure to act and gross neglect of duty have resulted to the financial prejudice of PhilHealth and the healthcare providers, as the case may be. While SVP for Legal Sector Rodolfo de Rosario projects that he is against fraud, it seems that the records prove otherwise, considering that a lot of cases are still pending or enacted upon by the agency. Another topic relative to the irregularities in the PhilHealth's legal sector that puzzled this committee is the agency's supreme power. Ito, Mr. President, daig nila Supreme Court. To modify, if not disregard, the final decisions made by higher courts. But hindi to. During the course of the hearing, the case of Perpetual Soccer Hospital was brought up due to the irregularity done by the PhilHealth Board by not executing the decision of the Court of Appeals, which affirmed the earlier decision of the PhilHealth Board to impose the 3-month suspension of accreditation of the said hospital and for the payment of 10,000 pesos to PhilHealth. The said act is a clear violation of the doctrine of immutability of judgments. Likewise, in so doing, it is as if PhilHealth tolerated the fraudulent act of Perpetual Soccer Hospital. And ultimately, such action of PhilHealth further caused losses from the coffers of the agency by reason of the releases the PhilHealth made to the hospital during its supposed suspension. Suspended dapat eh. Had PhilHealth implemented the board's earlier decision, which was affirmed by the Court of Appeals, then okay sana. But it was revealed by SVP Del Rosario during the hearing that the basis of the board is changing the penalty to payment of fine amounting to 100,000 instead of the 3-month suspension and a fine of 10,000 is a board resolution allowing the conversion of decision affirmed by higher courts. Kaya maliwanag, nandun po sa record yung sinagot niya. Sabi niya, anyways, to answer your question regarding the perpetual sugar, it was a decision by the PhilHealth Board of Directors based on a policy that was decided even before I was appointed. Inuturo niya yung board. Talaga naman meron board resolution to that effect. Since the action of the board in converting decisions of higher courts was anchored on and backed by an earlier board resolution, the Perpetual Soccer Hospital case is not the first case whose decision was converted by the board, as narrated by Corporate Secretary Jonathan Mangawang on 11 August hearing of the committee. Siya mismo nagsabi nun, I quote, PhilHealth Board decision of perpetual case is not actually the first decision of the PhilHealth Board where it modified a decision of the Court of Appeals. Supreme Court. Mr. President. Although the PhilHealth Board has quasi-judicial powers, its powers are only exercisable in matters that are within its jurisdiction, particularly when the cases are still pending the agency's decision. And it does not extend when a higher court has already acquired jurisdiction over these cases. It is already well settled, as stated in the 2004 case of NHA versus Court of Appeals, that a decision that has acquired finality becomes immutable and unalterable, and may no longer be modified in any respect, even if the modification is meant to correct erroneous conclusions of fact and law, and whether it may be made by the court that rendered it or the highest court of the land. Mr. President, another issue related to the irregularities in the legal sector of PhilHealth is the diluted cases against erring PhilHealth officials. In an incident involving some employees of the PhilHealth Regional Office Region 2, were involved in an advertently depositing 9.7 million in Balanga Rural Bank, which is supposedly supposedly due to B. Brown Avitum Philippines and be deposited to its bank account, Bank. During the August 11 hearing, it was established that this blunder by the subject employees of PRO2 was solely be blamed on human error. Now, to wit, Ms. Aragona, yes, as far as I can remember, sir, yung balanga, when it was reported to us, ang naging problema po yata isang pag-select ng bank for the transfer. So I think there was an incident report on that. Yung doon sa mismong ano natin na region. So I had to get the details. Pero yung po yung natatandaan ko na. So there were something na nagkaroon ng error sila doon sa pag-select. Senator Lacson, anong klaseng error? Man-made itong error na to? Hindi pwede siyang machine ang mag-error dito kasi very strict kayo sa mga online transactions. Ms. Aragona, opo. Senator Lacson, hindi pwedeng mag-crossover ng regions kasi ina-apply nga yun. However, Mr. President, despite the substantial amount involved in the infraction of the employees or the employees involved, only a simple neglect of duty was filed and meted out against them. In a similar vein, as pointed out in the committee hearings in the case of Pamela Del Rosario, which involved fraudulent claims amounting to 1.17 million with the indispensable participation of the PhilHealth employees. Based on the investigation report, Regional Special Investigation Team of PhilHealth dated May 6, submitted to then Regional Vice President Dr. Leo Douglas Cardona Jr. He recommended cases to be filed against the erring employees were dapat syndicated estafa, falsification of documents, usurpation of authority or official functions, violation of the PhilHealth law, serious dishonesty, gross neglect of duty, grave misconduct, among others. Yet, what was filed against the employees involved were just simple misconduct. When the PhilHealth resource persons were asked regarding this, none of them denied the report. Another case in point to prove the dilution of cases by PhilHealth officials is the very case of Attorney Del Rosario himself, SVP for Legal Sector. Although the case happened when he was the head of Physical Infrastructure Resource Department, as raised during the August 11 hearing, Attorney Del Rosario was charged together with one senior vice president with an administrative case of budget insertion relative to the construction of PhilHealth's corporate center. While the senior vice president was relieved from his office, Attorney Del Rosario was just found guilty of simple neglect of duty and was fined amounting to his 15-day worth salary. E pagkaganyan, Mr. President, mawiwili talaga yung mga katarantaduhan ng mga empleyado. Pagka ganun-ganun lang ginagawa natin. If the internal policy in PhilHealth is really to grant its employee impunity or impose on them penalties that are not commensurate to the violations committed, the committee is not surprised why the performance of the agency is very dismal and deplorable. It could be easily deduced that there is indeed a systemic problem in PhilHealth that has to be immediately remedied, especially that the agency plays a vital role in the delivery of the healthcare services in the country. Which brings me now, Mr. President, to the recommendations of the committee. The Committee of the Whole consolidated in this report all the inputs, particularly the recommendations submitted by the following senators: Senator Pampilo Lacson, Senator Juan Miguel Zubiri, Senator Franklin Drilon, Senator Sani Angara, Senator Pia Cayetano, Senator Aquilino Coco Pimentel III, Senator Grace Poe, Senator Francis Tolentino, and Senator Cynthia Villar. Considering all the findings of the Committee of the Whole that this representation just presented, we therefore recommend the filing of criminal charges against the following. Number one, Attorney Rodolfo De Rosario Jr., Senior Vice President for Legal Sector, and all other PhilHealth officials and employees as may be determined by the Department of Justice, who connived with and participated in the consummation of the punishment illegal act, particularly for their failure to act upon and or neglect of duty to cause the prosecution of cases before them. Article 208 of the Revised Penal Code, prosecution of offenses, negligence, and tolerance. Violation of Republic Act 3019 or the Anti-Graft and Corrupt Practices Act. Number 2, Ms. Jovita Aragona, Senior Vice President for Information Management Sector. Mr. Calixto Gabuya Jr., Acting Senior Manager, Information Technology and Management Department, and all other PhilHealth officials and employees who connived with and participated in the consummation of the punishment/illegal act, particularly for their act of overpricing IT supply and the concealment alteration of documents pertaining thereto. Article 171 of the Revised Penal Code, falsification by public officer, employee, or notary, or ecclesiastic minister. Article 213 of the Revised Penal Code, frauds against the public treasury and similar offenses. Article 226 of the Revised Penal Code, removal, concealment, or destruction of documents. Violation of Republic Act 3019 or the Anti-Graft and Corrupt Practices Act, in violation of Article 2 of Republic Act 9184 or the Government Procurement Reform Act. Number 3, Secretary Francisco Duque III, Chairman of the Board, Brigadier General Ricardo Morales, former President and CEO, Mr. Arnel De Jesus, Executive Vice President and Chief Operating Officer, Mr. Renato Limsiaco Jr., Senior Vice President for Fund Management Sector, Mr. Israel Francis Pargas, Senior Vice President for Health Finance Policy Sector, and all other PhilHealth officials and employees who connived with and participated in the consummation of the punishable illegal act, specifically for their improper and illegal implementation of the IRM, the Interim Reimbursement Mechanism, against its duly authorized purpose under the law, and for their grave abuse of discretion or gross negligence in ascertaining the IRM beneficiary without valid criteria for distribution. Article 217 of the Revised Penal Code, malversation of public funds or property. Article 220 of the Revised Penal Code, illegal use of public funds or property. Violations of Republic Act 3019 or the Anti-Graft and Corrupt Practices Act. Number 4, Mr. President, Secretary Francisco Duque III, Chairman of the Board, Brigadier General Ricardo Morales, former President and CEO, Mr. Arnel De Jesus, Executive Vice President and Chief Operating Officer, Mr. Renato Limsiaco Jr., Senior Vice President for Fund Management Sector, Mr. Israel Francis Pargas, Senior Vice President for Health Finance Policy Sector, and all other PhilHealth employees and officials who connived with and participated in the consummation of the punishable illegal act, specifically for their failure to withhold tax liabilities of healthcare institutions to which they released IRM funds, and for their act of charging the corporate operating budget for failure to withhold the taxes in the advancement of funds through the IRM. Article 217 of the Revised Penal Code, malversation of public funds or property. Violation of the National Internal Revenue Code. Violation of Republic Act 1051. violation of Republic Act 3019 or the Anti-Graft and Corrupt Practices Act. Mr. President, in addition to the criminal charges that the committee recommends to the Department of Justice and the Ombudsman, we also recommend to the DOJ and the Ombudsman to file against PhilHealth officials and employees administrative cases. This committee likewise recommends them to file administrative case against Brigadier General Morales and SVP Dennis Mas, Management Service Sector, for not implementing the board resolutions on courtesy resignations, which is clearly a neglect of duty and insubordination. File administrative case against General Morales, Executive Vice President and COO Arnel de Jesus, and Mr. Arnel de Jesus, Executive Vice President and Chief Operating Officer, for violating COA rules on the period of liquidation in issuing Memorandum Circular 2020-032. File administrative case against Attorney Rodolfo Del Rosario, SVP for Legal Sector, and all other officers and employees of the Protest and Appeal Review Department of PhilHealth for failure to act in gross neglect of duties relative to the cases pending in their department. Ensure that the administrative and criminal cases are timely filed against responsible individuals, healthcare institutions, and corporations. Filing charges against responsible individuals, healthcare institutions, and corporations will prove PhilHealth's and the government's commitment to ensure that government funds are not mismanaged and that corruption is not tolerated. Further, cases and subsequent convictions will serve as a deterrent for others with corrupt intentions. Given the observation of the B. Brown Avitum Philippines Incorporated, evidence for ghost patients must be sought after. The report recommended that this can be done by retroactively matching the latest death data from the Philippine Statistics Authority. And also recommended to PhilHealth. Here are some of the committee's recommendations. Immediately require from the healthcare institutions which received IRM funds to liquidate the utilized IRM funds and return the unutilized amount. Impose a definite deadline, therefore, and strictly implement the same. For PhilHealth to immediately pay the claims of private hospitals, prioritizing those which are COVID-19 referral hospitals and those with high cases of COVID-19 admissions. Increase the involvement of the COA in PhilHealth in every stage of operations of PhilHealth. As revealed in the hearings, the Commission on Audit is having a hard time in auditing PhilHealth due to the difficulty of obtaining documents from PhilHealth. Central Office, lalo na. So COA should be allowed to pursue its mandate to conduct the necessary audits even at the regional level without any hindrance from PhilHealth to ensure that government funds are properly managed and spent. Outsource the IT services of PhilHealth. PhilHealth should simply outsource to a reputable company the provision of its IT services, which include but not limited to development and provision of a reliable electronic health records and analytics system, specifically for membership data information collection and membership services. For PhilHealth to contract out the processing of its benefits claim to avoid backlogs and massive reimbursement delays. This would simplify the reimbursement process, remove red tape, and address corruption. The Senior Vice President, Legal Sector must have at least 5 years of legal practice or have held a public office requiring admission to the practice of law as an indispensable requisite. Also, for the high-ranking officials of the PhilHealth Insurance Corporation or the Philippine Insurance Corporation, starting from the Chief Executive Officer to the regional vice presidents, to file their courtesy resignation in compliance with the board resolution in relation thereto, and to be able to give the President of the Philippines a free hand to appoint new officials for the people to regain its trust on PhilHealth. For PhilHealth to implement a regular reassignment of its regional vice presidents to a different region every 3 years. No regional vice president should be reassigned to the same region more than twice in his or her entire tenure in PhilHealth. For PhilHealth to strengthen its enforcement and legal division in the various regional offices to help expedite and ensure the success in prosecuting cases, whether pending in PhilHealth or those filed in regular courts or quasi-judicial bodies. As for the Department of Budget and Management, Mr. President, the committee is calling for the DBM through its procurement service to execute the necessary procurement in PhilHealth's stead on the latter's information technology needs, whether hardware or software. Another recommendation of the committee that will provide additional layer of protection to ensure PhilHealth will be financially sound and solvent and that transaction fall within acceptable parameters is for the Insurance Commission to be involved in scrutinizing the operations of PhilHealth. For the GOCC, for the Governance Commission for GOCCs, I should say, as the governing body for government corporations, the committee urges it to actively and decisively perform its mandate as a central advisory, monitoring, and oversight body of PhilHealth. In particular, it should identify the necessary skills and qualifications required for appointive directors to the PhilHealth and consider the suitability and qualifications of the candidates before submitting its recommendations to the President. The fit and proper rule should be strictly applied. The directors must be chosen based on their integrity, experience, education, training, and competence, among others. Take a proactive role in evaluating the performance of PhilHealth, its directors and officers, and discipline them if necessary. Conduct periodic evaluation and assessment of the performance of the PhilHealth. Require reports on the operations and management of the corporation, particularly on the management of its assets and finances as provided. Recommend appropriate measures to improve PhilHealth's overall performance and service delivery in accordance with its mandate, based on its most recent performance scorecard. And last, for the GCG, we call on them to conduct a special audit for PhilHealth's finances, possibly in the last 5 to 10 years. The committee is likewise seeking the Anti-Money Laundering Council for it to immediately investigate and determine whether the bank accounts of those PhilHealth officials and private entities that have been implicated in the malversation of PhilHealth funds fall within the category of the so-called suspicious accounts. And also, Mr. President, for the various Senate committees, the Committee of the Whole has provided for a number of recommendations that are contained in this report that we expect could be timely acted upon. In closing, Mr. President, our country is in dire straits. Gross domestic product shrunk 16.5% from a year ago, according to the National Statistics Agency, the worst reading in a data series going back to 1981, and that is a fact. The pressure on government finances becomes even greater as we try to implement the Universal Health Care Act, which aims to cover all of us. PhilHealth is in a deep hole as well. How deep, we are not certain yet. unless we discover the real state of PhilHealth finances, we will never know. And that lack of knowledge is something all of us can ill afford to have. High unemployment caused primarily by the closing of businesses due to COVID-19 will result in fewer individuals from whom PhilHealth can exact premiums. That is another blow to PhilHealth, Mr. President. As if that is not bad enough, PhilHealth is hemorrhaging because of inefficient running of the corporation, compounded by corrupt practices inside. Fortunately for us, the latter two causes are preventable and can be solved by us. We must thus exert our utmost authority and vigilance to rid PhilHealth of undesirables and punish to the fullest extent of the law criminals. Less than this we cannot allow. Our suffering people deserve nothing less. Mr. President, public service demands total honesty from its public officials and employees. And may I add, using the classic admonition by the ancient Romans, they must not only be pure and honest, but also perceived to be pure and honest, like Caesar's wife. Thank you. Good afternoon, my dear colleagues, ladies and gentlemen.